Kevin Rundlett with Rundlett Law Firm. I am a workers' comp attorney. Today what we're going to talk about in the workers' comp realm is, should you go to a final hearing or should you settle your workers' comp case? Most people don't understand. In a workers' comp situation, the trial is not really a trial, and that's the reason that we call it, or that the workers' comp world calls it, a final hearing on the merits of a case. It's not the typical trial that you would see on a TV court show with a jury and all the objections. It's similar, but it's not the same. So I'm going to talk about some of those differences and what you might expect if you decide to go that route. So the first thing you need to know about a final hearing on the merits in a workers' comp case is that it doesn't really close your case. The only thing it does is give the judge an opportunity to determine whether it is a compensable case, meaning, did it happen on the job? Was there a real injury? And then the judge is going to probably decide on the wage portion of the claim, because in workers' comp cases, injured workers are usually entitled to some form of compensation for lost wages. And it's different in different types of cases, but that is something that the judge would be trying to decide. So at a trial or a final hearing of the merits in one of these cases, it's usually a small room. There will be a judge, an administrative judge in the workers' comp world. There'll be a court reporter who's taking down all the testimony. Usually the defense attorney is there, and he might have a representative from the insurance company that's on the claim. And then it's going to be you and your attorney. And sometimes your attorney is going to call you. Usually you're going to be called as a witness, and we'll have another video later about how to testify in the right way. And then that may be it. Medical records oftentimes are stipulated to, meaning both sides agree, these are the medical records. Here you go, judge. Look at them and tell us what you think. So that's kind of a nutshell of what happens at a trial. The problem if you go that route is that you're going to remain under the thumb of that insurance company. The insurance company still gets to approve all your medical treatments, because if you prevail at that hearing on the merits, then your medicals will remain open for your lifetime, so long as you get treatment for that injury at least once a year. But I think most people realize very early on in a workers' comp case that it's frustrating, because your doctor, the person who's trying to make you better, may prescribe a certain treatment, medication, physical therapy, and oftentimes the insurance company either delays approval of that or they deny it, where your attorney has to come in and fight to make it happen. So your treatment's actually delayed. It's very frustrating. So usually the best thing to do in a workers' comp case, when everything lines up right, is to try to get a settlement, meaning the insurance company will pay a lump sum to you for you to sign some documents saying, we're done with this. Y'all are not involved anymore. I'm gonna handle my own medical treatments from here on, and you can wash your hands of that. Sometimes we call it a divorce from the insurance company. That's really beneficial to the client. So in the settlement, they'll pay you something for your wage argument, and there are some arguments as to why it should be more or less on either side. And they'll pay generally something for future medicals if your doctors have indicated that that's necessary. So I hope this helps. Check us out, subscribe to our channel. You'll get notifications when new videos come out. And I appreciate you watching, and I hope you have a great day.